Hello, everyone, and welcome back to Legacy Lawyers. This is Nathan Croxford coming to you today with Brian Edwards, my oftentimes sidekick on our podcast. And before we begin today, we are going to get right down to business. But before we begin, we just wanted to remind everyone that our podcast, while we are both estate planning and asset protection attorneys, our podcast is not intended to be legal advice. Please seek out a qualified attorney in your area, in your jurisdiction, wherever you might be listening, for advice on your specific situation. Or you can contact us and we can talk about entering into an arrangement where we could actually give you legal advice. But for today's purposes, everything that we're talking about will be for educational and entertainment purposes only. So with that, Brian, I'm going to start peppering you with questions right out of the gate. And I want to start with a number. How many states in this country allow for something we'll describe later, but it's called a domestic asset protection trust?
Yeah. Hi, Nathan. Good to see you.
Good to see you
Happy
too.
to be here. Happy to answer your question. It depends on who's counting. There's a core group of about 17 states with strong, well-established statutes. By the most recent count, as many as 21 states have something, but either way, it's fewer than less than half the country. Fewer than half the country. That's what I meant.
Fewer than half, but lucky for us, Utah is one of them, and it's one of the stronger ones, right?
Yeah, that's right. And that matters more than most people realize because what a domestic asset protection trust, we might call them DAPs or like a UDAP for the Utah
Yeah, the
Domestic
Utah
Asset
one, we
Protection
refer
Trust.
to that as a UDAPT a lot.
Yeah. They allow for you to do something that used to require going offshore, setting up a trust like in the Cook Islands or the Cayman Islands or Switzerland. You hear about that a lot. That can cost a lot of money, anywhere from $40,000 to $50,000 just to establish it.
Mm-hmm.
Thousands of dollars every year to maintain it, and you have to file international tax reports with the IRS just to keep it running.
And so what we're saying is that Utah offers essentially the same fundamental protection domestically here under Utah courts administered by Utah trustees and at a fraction of the cost.
Yeah. And in the majority of states, the ones that don't have this law that we have in Utah, if you set up a self-settled trust, which is a trust where you're the beneficiary and you're the trust maker or the grantor or the settler, whatever you want to call it, creditors, they can still reach your assets within that trust. The protection that comes with the asset protection trust or ADAPT or what we're talking about today just doesn't exist in a self-settled trust.
Yeah, and even in Utah, certain types of trusts, most types of trusts don't provide that. So a big misconception that we want to kind of blow up right off the bat is that a revocable living trust does not provide any asset protection. When we
Correct.
say that a revocable living trust is protecting us, what we're talking about is protecting us from probate, maybe protecting us from family discord, maybe protecting a special needs individual if it's drafted properly from having assets coming to them in a way that would disrupt their disability benefits. But otherwise, you have to use a specific type of trust. And like we've said, most jurisdictions don't even allow for it. So today we're going to talk specifically about what Utah's DAP, Domestic Asset Protection Trust, does, how it works, who it's for, which that's also going to be, I think, eye-opening for a lot of people because I think most people think this is only for the super wealthy. That is not the case. This is for anyone who's looking to protect assets from creditors and lawsuits. We're going to talk about what the rules are. And because this is a tool that most residents with liability exposure have never heard of, they need to. So that's what we're going to do.
Yeah, we're going to talk about some specifics. I mean, we'll refer to the statute, we'll refer to the rules around how to create and what's going on here, what you can and can't keep in the trust, the whole picture. We'll also talk about how Utah compares to other states. That's part of this as well. People usually hear about some of the other states. The ones that come to my mind that I did hear about before doing this was Nevada and South Dakota, but we'll get into it.
Yeah, and I think Alaska was the first to allow it. So let's start with who this is actually for. Like, who should consider or who might be a good candidate for an asset protection trust, a Utah asset protection trust?
Yeah, and I think You mentioned it's not necessarily the super wealthy. When I hear offshore, and like we mentioned offshore already in this podcast, to me that's like ultra wealthy, just trying to get your money somewhere. Then that is not who we're referring to in this situation at all. Let me just paint a picture of who we
Although
see.
those people can use these
Oh, for sure.
just as effectively, but we're not, I guess what we're saying is it's not limited to the hyper wealthy.
Correct. Yeah. Generally, and what we see most of the time is this is like a small business owner, really is the classic case that I see. Someone who's spent about 15, 20 years building something real, like a contractor or a restaurant owner, somebody running a small manufacturing shop, or even like an attorney or a doctor, something like
Hmm.
that. They're not sitting on a yacht. They're working hard every day. They're disciplined, trying to make sure that their assets that they built themselves are protected.
So give me like a concrete hypothetical example.
If I can give you, if you don't mind, I want to give just a fun example real quick. I got little
Yeah.
kids at home. This is what I'm picturing. We have blocks, we have the magnet tiles and all these things. My son, if he wants to build something, he does it well and it's great. And then my daughter comes and is like, I'm just gonna tear that down and breaks it and ruins it. It's like, what did I just do? I just built this huge thing and it was what I wanted, and you just came and ruined it. Kind of the same thing. As somebody who actually builds something like a business is what we see a lot. So picture somebody who they have a business here. They maybe have a rental on the side. They have a pretty good brokerage account with 500,000 or more in it or something like that. These are just numbers. Like, it doesn't have to be these
You're just
numbers,
making
right?
this up. Yep. Not a billionaire.
Yeah, exactly. Not a bad, just somebody who can build something and wants to protect it, not have somebody come and destroy it right in the middle of it.
Okay. So, and the key here is that most of the people that you mentioned are business owners or professionals where what they do every day is creating liability exposure for them.
Exactly. Constantly. Every contract someone signs or every time you hire somebody, every customer who comes through the door is a potential source of liability. Whether it's a business dispute, an employee claim, or like if a lease goes south or something like that, even if there's a slip and fall in a rental, lots of landlords have come in and they have tenants and a slip and fall in that car or in that house. A
Hmm.
car accident, where you're at fault sometimes as well. Every one of those isn't just the business on the line. Personal assets are on the line and can be targets in a lawsuit like that.
Yeah. And most business owners or people that are out there working hard, building something meaningful, and at the same time creating exposure for themselves, a lot of them, I think that their only options are insurance, hope, or I guess the extreme case of moving money and assets offshore, like we've talked about.
Right. And I'll say this without any sarcasm. Offshore trusts are a real tool and they do provide strong protection. But as we already mentioned, they cost 40 to 50,000 to set up sometimes. You pay annual foreign trustee fees and you have to file federal forms to report them just for the IRS just to keep them alive. They attract a lot of scrutiny. They're complicated. But for the normal Utah business owner that we're trying to paint a picture of here, that level of complexity is widely out of proportion to what they actually need.
Yeah, and especially if there's a tool right here at home that offers that kind of core protection, but on a completely different scale, right?
That's right. Yeah. Their assets, the Utah business owner or any Utah resident that we're talking about, their assets go into an irrevocable trust and they can remain a beneficiary, and future creditors, people who sue them after the trust is funded, can't reach what's inside that trust.
Which is huge.
Yeah, it's huge. Yeah. In Utah, if we do a domestic one, it's at the fraction of the offshore costs. And just to be clear about something, this isn't a tool just for the wealthy. Like we've said, it isn't tied to any one profession. At its core, it's for anyone with assets they care about and a real concern with those assets being exposed in a lawsuit or a creditor claim. Business owners, again, contract, physicians, dentists, landlords, anybody who's at risk or has some type of risk in that situation.
Yeah. So the common denominator, I guess, isn't a net worth type of an analysis. It's not a job title. It's if you are somebody who has worked hard, built something, or maybe you inherited a large amount of money or assets, and you have concerns about future creditors, lawsuits, and things of that nature. I just, on a personal note, had a family member who was involved in a vehicle motorcycle accident where the family member, it was thankfully not super serious, but the motorcyclist was injured. My family member was found to be at fault. Obviously, just negligence, not anything on purpose, but
Yeah.
they now are facing the prospect of having a plaintiff suing them for, I'm guessing, a couple $100,000. And in this case, I think insurance is going to cover it. But it's such a better feeling to know that you've taken the main assets that you've spent your lifetime building and saving for, and you've put them behind a protective wall.
Yeah. And on it, you mentioned it, but the key word here is future. 'Cause the
Yes,
tool
future
works,
creditors, right?
yeah,
Future
future creditors.
plaintiffs.
The tool only works if you're playing before a claim arises, which is why you want to explain the mechanics before we get to the season period. But we'll get to that because I mean, it's future creditors. What I tell people all the time, you can't predict when you're gonna get sued. Nobody knows. You could get in a car accident easily today. What you just said, it could happen to anybody. Just a planning mechanism to help us with any future creditors that may come out of the woodwork one day.
Yeah. Yeah, it's interesting. I'll sometimes talk to people and we'll talk about, should we do a revocable trust? Should we do an asset protection trust? The client will kind of go back and forth, and ultimately, in some cases, they'll just choose to go with the revocable trust because it's simpler and they don't think that they have any likelihood of being sued. They've never had any experience being sued. And it's always disappointing and sad to me when I get a call a couple of years later from that same client and they'll say, hey, remember we talked about that one kind of trust that protects against
Yeah.
lawsuits and the like? And I'll say, yeah, I remember that. And then they'll say, could we do that? And I'd say, yeah, absolutely. Come back in, we can put that in place. But then I always ask, why do you ask? And way too many times it's because, well, and we just had something happen and we either just got served or we think we might be sued in the near future, at which point I have to kind of tell them that's not a future claim. So the key here is, if you're in a position where you do not have any claims pending, you don't have any lawsuits against you, you don't know of any lawsuits, that's the time to do this, right? So there
Yeah.
is the timing is important. So let's kind of talk about how this works, and let's maybe start from the beginning. What is the legal theory that makes this work? Because for a long time, there were no jurisdictions anywhere in the United States where a self-settled trust, where you're both the trust maker and a beneficiary, could provide creditor protection. That was just not legally recognized.
That's right. Yeah, that's the traditional rule in common law. If you could benefit from a trust, creditors can benefit from your trust as well. You couldn't
Mhm.
hide your assets from creditors in the trust you created for yourself. That rule protected creditors from debtors who tried to shelter everything and then discharge their obligations.
Yeah, and then Utah and other jurisdictions changed that, but specifically, let's talk about kind of the timing of the Utah, when it changed in Utah.
Yeah. I mean, the first state that did it was Alaska. They did it in 1997. You mentioned that. Utah enacted their statute to create this type of trust in 2013. So about
Mhm.
13 years ago. It still feels pretty recent. You talk about law in general. That's a pretty recent
Yeah,
law.
that's very recent.
Yeah.
So go
Yeah.
ahead, sorry.
I was just gonna say it's one of the, so it's not the first one, right? It addressed some weaknesses in other statutes from other states, creating one of the strongest frameworks in the country, to be honest.
Yeah, and I was actually around when I was practicing when this happened. And I just know that for the first little while, even though Utah had an asset protection trust statute, it wasn't very good. And a lot of practitioners avoided it. I'd say for the most part, no one was using it. And it was a few years after that, I don't have that date, but where there was a significant effort to revamp the statute. And once that revamp occurred, this law firm, me, Mike Haslam, the other founding partner of Voyant Legal, we looked at it and we realized, man, Utah just did a major overhaul, and this is one of the best in the country. So that's when we started using it. And it's just kind of gotten better as time's gone on. So walk me through what the actual structure looks like.
Yeah, so the trust is an irrevocable trust, and don't let irrevocable scare you. It just means that once you put your assets into the trust, You can't just turn around the next day and try to pull them out pretty easily. You have to go through a couple rules and a couple structures to get through that. And we draft, we're not going to get into this right now. There's a ways to make it so that you can still change things within the trust later, but
Mhm.
we're not going to get into that
Yeah,
today. But
irrevocable doesn't mean that it can't be changed. The
yeah,
trust can still be amended. There's just specific ways that you have to go about it.
exactly.
Assets can be accessed. There's just a specific way that you have to go about it, right, in
Yeah.
order to comply with the Utah statute.
Exactly. And the trust has to state that it's being governed by Utah law and that's established under Utah DAPT statute. And without that language within your trust, you don't get the protection. And it's honestly probably one of the easiest things to do in drafting this trust is look at that statute, more or less copy and paste it into the trust. Like it's a
Yeah.
pretty easy thing that we do here for sure.
Yeah, and when you look at this trust compared to like a regular revocable living trust, there's an entire section, multiple pages long, that addresses all the statutory requirements and calls those out and cites them so that we make sure we comply with that requirement. So once that trust is established, then you're going to transfer some assets in, right?
Yep, just like in any estate planning situation, a trust is only as good as it's funded, as it has assets in it. So you can transfer your assets into the trust. I mean, it can be investment accounts, it could be real estate, it could be business interest, it could be your cash. Anything that you want to protect, you can put into a UDAP. And then once they're in the trust, you no longer personally own them. That's kind of how you get the protection.
Mhm.
And then under Utah code, creditors cannot compel the trustee to make distributions either from those assets. They cannot attach distributions before they're paid and cannot reach your beneficial interest in the trust either.
Yeah, so the key here is that you, the trust maker or trust makers, so the classic case is either a single individual or the other classic case is a couple who are the trust makers. They can act as trustees, but we've taken the distribution power, that one power, away from the trust makers who are the trustees, and we've given that to somebody that will explain in a little bit more detail later, called a distribution trustee. So that distribution trustee is the one that has to authorize distributions to be made, right?
That's exactly right. Yeah, that's really if you compare it to like a revocable living trust, that's the biggest difference is that
Hmm.
trust makers, they can stay trustees of assets within the trust, still make investment decisions, still do what they need to do. But the minute, yeah, you want to try to distribute something, that's where you have a distribution trustee come in, and they will have the power and the authority, I guess you can say, to make those distributions.
So why does that matter for creditor protection?
Yeah, that's a good point. Or a good question. If you can compel distributions from your trust, a court could order you to exercise that right, and then they can take that distribution in that process. But the moment you can compel money from the trust, creditors can also ask you to compel that money to come from the trust as well. That's where you don't have protection. It's gone. So the lack of a distribution right that you can force or that you can compel, that's what makes an asset protection trust. You can no longer say, "Hey, give me this money." The distribution trustee is the one who has the ultimate decision making power to say, "Yes, I will give you this money."
Yeah. And I think the key here is to help people understand why is if you're involved in a lawsuit, let's say it's a car accident. This is a classic example.
Yeah.
A lot of times, a car accident, there might be one, we'll use a married couple. One spouse is driving the vehicle, but in the resulting lawsuit after the accident has happened, both spouses end up named in the lawsuit because one was the operator and the other was the owner, or both spouses were listed on the title of the vehicle, so they're also a vehicle owner. So in that case, they're both under the jurisdiction of the court. And if their trust allows them to access money, make distributions without any intervening authority, then the court could compel them to do that. The key is that the distribution trustee is going to be someone who would not be named in that lawsuit. They weren't involved in the accident in any way. They had no ownership in the vehicle. They're truly independent, and therefore they're not under the court's jurisdiction, and a court cannot order them to exercise the distribution power, right? And I think the key here is that while we do want to work with people who are friendly to us, right? You wouldn't want to name somebody that you don't trust or somebody that doesn't have your best interests in mind as your distribution trustee, but they do genuinely have to be independent.
Yeah, and the other thing with that too, then the statute does say this, is that that distribution trustee must also be a Utah resident. They could be an individual or a Utah licensed trust company. But I mean, going back to you said, yeah, they have to be independent, and know that they can make an independent judgment on distributions. So I mean, when we're looking around trying to find someone we trust, trying to find the best candidate, having a conversation with them, just letting them know you still have independent authority to make these decisions. We hope that you're working together to make these distributions and kind of go from there on that.
Yeah, you're looking for somebody, and I think we might talk about this a little later. You're looking for somebody that you can work with in a collaborative capacity, right?
And
Rather than in
I
any
usually
kind of
say someone you
adversarial
yeah,
capacity.
yeah, someone you can lowercase t trust
There you go.
in these situations. Yeah.
There you go. And Utah trust companies can serve in that role, but I think the major issue there is that the cost to have like a Bank of Utah or Zion's Trust company, or any kind of large, big box trustee, is the costs are going to be pretty high for that. So the
Yeah.
other thing that we want people to be aware of is if you don't have an extended family member or a friend who could fill this role, there's also independent professional trustees that's what they do, and they're not part of large trust companies. As long as they've been approved to do that work, they could act in that capacity as well. I think for the most part, our clients are usually able to find somebody within
Right.
their circle to act in that capacity.
Yeah.
I think one of the things that might surprise people, especially when you talk about an irrevocable trust, people hear that word, they're like, man, not flexible. You can't access anything. You can never change it. I think people would be surprised if they understood how much control they actually keep.
Yeah.
What kind of power and freedom and flexibility does the grantor or trust maker retain?
Yeah, they can still be a trustee of the trust. They're just not the only trustee. That's just the only thing is the distribution. But things that you can hold on to is you can still veto any investment decisions. You can actually veto any decisions as well. You can have a limited power of appointment. That just means that you can still make changes to your beneficiaries. If you want to change anybody in the beneficiary, you can live in your home that's held by the trust. You can add or remove people as you need to, and advisors or anything like that. So there's still a lot of powers given to the trust makers in these trusts.
Yeah, and the way I kind of explain it to people is anything that has to do with managing the assets inside of the trust, you as the trust maker can do that just like you would in a revocable living trust or the more traditional trusts that people are familiar with. But
Yeah,
what really where the important distinction is that any distribution, any asset leaving that trust, that's when you have to involve and collaborate with your distribution trustee, right?
that's right. And generally, I mean, the assets that generally go into a UDAPT, the house, like a brokerage account, these big assets that you're probably actually not going to touch or try to get out of your estate or sell anytime soon.
Mhm.
Those are
Yeah,
really
those are
the assets.
perfect.
Yeah, those are really the big ones that go into the trust. But like a day-to-day bank account, like a checking and savings, generally that's something you can keep out of the trust. That's your operating. That's your, I use this money to buy my bananas and my gas. Like, you don't need to put anything like that in a trust. Why would you want you to go through your distribution trustee to go buy bananas at the store? Like, you don't.
Yes.
That's something that could stay out, and that's okay.
Yeah, and that's actually a good point because one of the things that I don't think that we were planning to get into, but I think I'm going to mention it anyway, is that you cannot, one of the best ways to make sure that this type of a trust fails is to get greedy or overzealous and to put literally everything you own inside of an asset protection trust.
Yeah,
You cannot do that. If you do that and you render yourself insolvent, then a court can pierce that trust, allow a plaintiff to pierce that trust. So it makes sense that you would not put your day-to-day bank accounts in there because A, you don't want to have to be running day-to-day transactions past a distribution trustee. But the other and maybe just as important reason is because you can't have everything inside of a trust, inside of a domestic asset protection trust. The other thing is that it kind of naturally works because there are certain assets that can't go in. So, for example, somebody that has a 401k or an IRA,
right.
And sometimes our clients have some pretty sizable balances in those accounts. Those have to stay outside of the trust, and that actually works in our favor when we're using a domestic asset protection trust because that prevents them from becoming insolvent as a result of using one of these.
Yeah, yeah, I agree with that. And we get asked that quite a bit, but it's in the statute. It just says right in the statute you cannot become insolvent by creating this trust.
Yeah.
We follow that part.
So we don't deal with this very much, but let's touch on it. There is the reason it's important to talk about is because this is where Utah really shines. There's something called a seasoning period. And this is kind of where the too late problem lives, right?
Yeah. And I think it's important to distinguish the seasoning period. There's look, this is the way I'm going to describe it. There's three types of creditors. Okay. There's
Okay.
future creditors that you don't know anything about yet and nothing's happened yet. There's creditors, something's happened. You may owe them money, but they haven't sued you yet to try to get their money. And then there's creditors who have sued you
Okay.
and they're trying to get their money. So the future creditors, when you create a Utah domestic asset protection trust, the minute you create that trust and it is funded and things like, and there's assets in it, you have protection against those future creditors. It's
Period.
there.
No
Period.
seasoning period required.
Yeah, no seasoning period. The seasoning period comes into play for creditors that you know about or something's happened, but they haven't quite sued you yet. It's just, hey, there's some money out there that they're trying to collect on behalf because they did a job or something at your house. I don't know.
Mm-hmm.
But there's creditors. That's where we have a seasoning period. Those creditors, they have a time frame that they have to then file a claim against you to be able to get their money back. And that claim period in Utah is 2
That
years.
seasoning period.
Yeah, that's the seasoning period.
Mm-hmm.
They have 2 years from the time of the transfer to then go after it and try to get their money at that point.
Or 1 year after they discover it, right? So there's
Correct.
still a discovery rule built in there.
Yeah,
So the later of 2 years after the transfer or 1 year after the time that they discover that you made the transfer into the trust.
correct.
And
That's
there's
correct.
actually a way to shorten that down
There is.
to 120 days. What does that look like?
Yeah, you can push it down to 120 days. You have to provide written notice to all known creditors. So anyone you currently owe money to or who has a claim against you, and you have to publish it to any unknown creditors in an appropriate way. You just have to let them know what the challenge window is for those notified creditors, and that's what 120 days. But after that, any pre-existing creditor who never files or anything during that time frame can be barred at that point. But
Yeah.
that's how you have to do. You have to let them know. You have to let them know that you created the trust. You have to let them know that there's assets as well to get that down from the 2 years to the 120 days.
Okay. And I'd say for the most part, we don't have a lot of that. Most of my clients that are using UDAPs, they've not yet been sued. They're not trying to use that trust to protect against a current lawsuit, an existing creditor, that type of thing. But we just need to make sure that everybody understands that it is possible to use it that way. And the 2 years that can be cut down to the 120 days of all the asset protection trust jurisdictions, Utah has the shortest seasoning period. So in that regard, that's one of the things that makes Utah one of the better states to do this type of trust, right?
Yeah, exactly.
So here's the hard part, though. What happens if someone tries to fund a domestic asset protection trust after they've already been sued?
So I think this falls into that third category. You've been sued, right? Creating the trust it won't work in that situation. They can get those assets.
Okay. Yeah. So there's something called fraudulent transfers. And that's basically when the second they find out they're going to be sued, they move an asset, right? The law prohibits that. And so that's where the timing of this matters.
That's right. Yeah. Any transfer makers can be considered voidable in that type of situation. So we want to make sure that if that's the situation you're in, you've been sued, creating the trust at that point just might be worse because the judge is going to take a look at your intents. They're going to take a look at the timing, and they're going to be able to unwind that transfer for sure.
Yeah. So again, we can't emphasize it enough that the best time to do this is now when you don't have any current existing problems.
Yeah, correct.
So,
Correct. It's when life is boring, right? The
so
best asset protection is when it's
yeah,
boring.
exactly.
So
Yeah. So I've been doing all the asking and you've been doing all the answering. Let's switch that up. What do you want to ask me, Brian?
Yeah, here we go. So there's a lot of states out there that have this, but again, one thing that comes up is how is Utah's different? And a lot of times we hear about Nevada. I think because and South Dakota, those are the two. Nevada's next door, right? I think
Hmm.
that may be one reason why we hear about Nevada a lot. But how
South
should someone
Dakota's
think through
pretty
that?
next door too, about one state over, but
That's true. They're pretty close as
yeah.
well. So, but what should we do? Why Utah?
Well, so it's pretty simple. Utah is one of a small group of states that have a really good asset protection trust statute on the books. Nevada and South Dakota are definitely on that list, and they get a lot of attention. But for the vast majority of people who we sit down with, the differences between these states are technical, don't really make any substantive difference. And really for somebody in Utah, the Utah Trust is actually a better fit because it's designed to be used in situations where the claims that you're trying to protect against have arisen in the state of Utah.
So, I mean, the protections that you get in any of
They're
these
very
states.
comparable.
Yeah. Okay.
Yeah.
Let's get some.
But we've kind of already said this, but the thing that makes Utah super competitive is that short seasoning period of 2 years, and the accelerated 120-day option is a lot faster than what most states offer.
And there's a practical side to staying in Utah as well.
Hmm. Yeah, big one. Utah requires at least one trustee be a Utah resident or a trust company. So for a Utah client, that's not a burden, it's a benefit. You get local administration, a trustee you can actually sit down with, a court system that you already are familiar with. If your home or your rental property is in Utah, then Utah is going to be the natural jurisdiction to set that up anyway. Setting up in a state where you have no connections usually means coordinating with an out-of-state trust company or professional trustee that you've never met. It can be more expensive and also forecloses on kind of using somebody that's in your circle, right? So for Utah, people living in Utah, Utah is definitely going to be the best option.
And I have a question after that. We may have some listeners outside of the state of Utah or in states
We
where
hope
they
we
don't.
do.
Yeah, they don't offer DAPs in their states. California, I know, is one that doesn't. So if somebody's from California or any of these other states, what should they do? Like, is this even a possibility for them? Can they go down this route?
Yeah, absolutely. They can do that. And Utah is one of the states that they could rely on, especially if they have any ties here. We have tons of clients that are from California and they own property here in Utah. The ski industry brings a lot of people from California here. So if you had property, I just not too long ago put together a family LLC for a family from California that was purchasing a property near one of the better ski resorts here in the northern part of the state, and it worked. That this would work great for them. So yeah, you'd never tell California client that Utah is the only answer. There are other options, but I would say if they have any connections here whatsoever, Utah is going to be the best option.
Well, that's great. We're going to switch gears just slightly then after talking about that. Let's make this a little more practical. If someone listening decides that DAPT makes sense for them and that's the route they want to go, what does that process look like and what does it cost?
Well, first of all, you need to find a good attorney to help you set this up. This is not something that you want to DIY. I would say under no circumstance would you ever want a DIY asset protection trust. So you'd want to engage a good attorney. If you're in Utah, you can find us at voyantlegal.com. You can call us at 801-951-0500 and would be happy to talk to you about doing this. But you want to make sure that the attorney that you work with understands asset protection trust work. So not even just every estate planning attorney is going to be familiar with this. In fact, there are a lot of people that end up coming to us because they asked about this at some other attorney's office and they just flat out said, we don't do irrevocable trusts. We don't deal with asset protection trust. You'll need to find somebody else that can do that for you. So we have made it a large part of our overall practice, the use of asset protection trusts. We think they're cool. We think they work great. We love the advantages that they afford. And so, yeah, you'd want to find a good lawyer to help you and go from there.
And I'm just curious, Nathan, in your practice, just
Uh-huh.
take a guess, the trusts that you do, like percentage wise, how many do you think have been UDAPs? How many people do this?
I would probably say a good 25% of the clients that we work with are now using domestic asset protection trusts. What do you think?
I'd
What's
agree
your
with that. Yeah. Yeah, they come in pretty frequently, and the benefits I think of a UDAPT are reasonable and they make sense, and clients see that, and then they want to go that route. So I think that's pretty awesome that they do that. So this is pretty. I mean, we've hit this before. UDAPT cost wise compared to like an offshore trust.
Well, you're talking a fraction, like offshore. I mean, I don't even know. It's been a long time since I've looked into anything like that, but we mentioned kind of the $40,000-$50,000 range plus the upkeep costs every year that could be in the thousands. Generally, when somebody in Utah is looking to do this, you're looking anywhere between say $5,000 to $15,000, depending on the complexity. And I would say for most of our clients, we're kind of on the lower end of that, depending on what they have going on. So considerably less than an offshore trust, and without the annual foreign trustees fees, without the IRS filings for compliance, and without the ongoing yearly costs.
Okay, great. So you pick an attorney, one that you like and you trust and you feel comfortable with. They draft the documents for you. What happens after that?
Well, in the process of drafting the document, you got to select your distribution trustee. That person has to be a Utah resident who meets the independent requirement. Could either be an individual in your circle, or it could be a professional fiduciary or a Utah licensed trust company. And there are fees if we're going to involve a professional, which is why most of our clients don't go that route,
Yeah.
especially if you're more active in utilizing what's inside of your trust and you want to access it more, then that's going to be the easier route's going to be somebody that's in your circle.
And then, I mean, after that, you fund the trust. And I don't know if we have time right now to go over funding, and we have other episodes that talk about funding. Can you just,
Yeah, I
gi-
mean, it's not much different than funding any other trust. I think the biggest thing is we have to sit down and kind of perform that analysis where we say what can go in the trust without making you insolvent, what has to stay outside of the trust to keep you solvent, what makes sense going into the trust from the standpoint of how you interact with that asset. Is the distribution trustee requirement going to be problematic? If so, then sometimes what we'll do is we'll set up a family trust, a revocable living trust, to sit next to the UDAPT, and we'll put assets that aren't a good fit into that trust so that those are protected from probate, but they don't have the same asset protection. But as I've said
yeah.
before, we have to do that. We have to be careful with that balance. So it's good that there are certain assets that can't go inside of the trust. That keeps us from violating the rule against making someone insolvent.
Okay. Good to know. Do you mind just saying real quick the tax treatment of the trust during
Yeah,
the,
that's actually one of the really, really cool features. Is a lot of times people that they hear it's an irrevocable trust, they go, oh, well, then it has to get its own tax ID number. It has to file its own income tax filing every year. And that's just not the case. During the grantor's lifetimes, this is what the IRS terms a grantor trust, meaning that any tax consequences of assets that are owned inside of this trust pass directly through onto the trust maker's personal tax return. The trust uses the trust maker's social security numbers as the tax ID number. And importantly, we get this question a lot because of some really bad media work. And there was a clarification by the IRS a while back that said certain types of irrevocable trusts foreclose on the ability to have a step up in tax basis on the assets after the trust makers pass. That is not the case in this particular type of irrevocable trust. You do still get a step up in basis. So that's huge.
that's awesome. That's really important. Yeah. For a lot of our clients, I think. And then, so some tax issues. One more thing I want to cover. What about the ongoing maintenance piece of a UDAPT? Is it enough just to set it up and then put assets in it and call it good?
I would say no. You want to make sure that you're doing regular reviews. If you're acquiring new assets, you want to make sure that those are accounted for, that they get funded in, that the trust documentation that goes along with purchasing new assets and putting them in that trust, that those are made. But there's nothing from a perpetual annual requirement standpoint that has to be done, especially if you're using an individual trustee. So I would say ongoing costs and commitments are pretty manageable.
Okay. And then lastly, just in this area of, the practicality of it, I create a DAPT, I create a UDAPT, and now I want to get money out of it. Can my trustee and I just agree, like, hey, we're just going to make sure I get money so much over time? Or do I have to go ask them every single time? Like, how does it actually look for me to be able to get my money out of my trust?
Yeah. Yeah. So the way that we've handled that is we created a very simple distribution trustee authorization that's about a half-page document that just documents that a distribution has been authorized by the distribution trustee and that money is going to be transferred out of the trust and to the personal bank account or the personal possession of the trust makers, right? The people that have caused the trust to come into existence. So if it's my trust, then I'm contacting my distribution trustee and saying, we're going to make an improvement and we're gonna go on a vacation and we want $10,000 out of our trust. Then it's a half-page form signed by the distribution trustee that authorizes that. We get a lot of questions about, well, I want to put my brokerage account inside of this, but in order to the concern I have with doing that is that I don't want to have to contact the distribution trustee every time I take money out of it. And we take money on a monthly basis. In that scenario, kind of the way that we've approached it is obviously you have to sit down and have a discussion with your trustee. They have to exercise independent judgment, but they could do something like an annual authorization where they say in the year 2027, I authorize a distribution to Nathan and Shannon of $2,000 a month from the brokerage account. Sign that, keep that record in the trust records, and then go ahead and set that up on an automatic so that those $2,000 get transferred out of the brokerage account into my personal bank account.
Awesome. Okay, so it seems very practical still. Like we can still use it. We can still get the money out. It doesn't take too much to set. It sounds like it's any other. The process of getting it set up and being able to use it is very
And funding it.
Nothing out of the ordinary when it comes to really an estate plan in general. How does this fit into from like a legacy office perspective? Like we have a UDAPT. How does that fit into estate planning overall, financial planning, tax planning?
Yeah.
What are we looking at there?
Yeah, that's actually a good question because as we keep moving forward in time, more and more people are looking to have all their advisors under one roof, right? So one of the emphasis that we've been focused on this year in our firm is creating that legacy office where you have your financial advisor, your attorney, and your tax strategist and tax filer all working side by side in what we refer to as a legacy office, a family office, if you will. And a lot of times a domestic asset protection trust is one component of that. But we want to make sure that we've got our financial advisor is aware that the brokerage account needs to be retitled inside of the trust. And what does that mean for the brokerage account? What documents need to be completed? What needs to change in terms of how money is accessed and so forth. We also want this to be tied into our overall tax strategy, and we want our tax filer to be able to understand what's going on so that when tax day comes around, we've got our tax returns lined up and ready to file in a way that takes into consideration that we're using this kind of a tool.
Yeah. And so even just from an estate planning, the trust allows for you to pick beneficiaries. If you
Yeah.
pass away, something, where does this money? Because
Same as if in a regular revocable living trust, right?
yeah, I mean, I'm a product. I don't know of anybody that spent all their money. Let's put it that way. So if you have money left over, which is likely going to happen, yeah, it can act just like a revocable and just say, hey, this is who's going to be my beneficiaries upon death.
Yeah, and just to be clear, this trust does everything that a regular revocable living trust does. It's just that, so it avoids probate. It can help manage family dynamics. We can have special needs trusts built inside of it. We can be very detailed in how we set up distributions for the residuary beneficiaries. All the things that you would want in a trust can happen inside of a Utah Domestic Asset Protection Trust. So why not have all of the things that a revocable living trust can offer, plus really robust asset protection built in?
Yeah. Honestly, this feels like it's just one piece of the overall puzzle of your state and your planning. I'm harking back to an episode I did with Mike just about a legacy office. We compared it to a football team, and you have lots of different players that do it and can help you out. And every player on the team can help you with this domestic asset protection trust. I'm kind of thinking this trust is kind of like the defense of a
Yeah.
football team, trying
Yeah,
to
absolutely.
protect yourself and protect your assets. But it's just one piece of the puzzle, of the overall puzzle. Being able to really work with everything that you have going on to make sure everything works out for you.
Yeah, so just to wrap it up, I know that was a lot of information. You might need to listen to this more than once to capture it all, but that's probably the best we can do in a 45 minute podcast episode. If you want more information on it, please contact us. Again, voyantlegal.com. That's VOLegal, LEGAL.com, or you can call us at 801-951-0500. Just keep in mind, not every state offers this. In fact, most states do not. Keep in mind that Utah is one of the stronger jurisdictions for this particular type of trust. And keep in mind that this is designed to protect against future problems. So the time to do this is not after something has gone wrong. The time to do this is now, while everything's calm, cool, collected. So if this has benefited you in any way, or if you know someone that could benefit from it, please share this episode with them. Brian, you can always find us, as you know, on Apple Podcasts, Spotify, YouTube.
That's right.
Any final words before the legacy lawyers sign off for today?
It's a great protective strategy. It helps, it works, and we are very well fluent in it. I can't think of how many, we've had plenty of trainings on this to help those of us on the newer end of it be able to learn it and know it and be able to really help our clients with it. It's a great strategy, protecting its future creditors and really helping anybody out that needs it.
Yeah, I'd echo that and just say that more and more we live in a society where people tend to be really inclined to bring lawsuits. So I'm always surprised when I meet people that just can't even conceive of how they might end up in a situation where they would need this type of trust. Trust me, it can happen quickly. You could ask my family members that were just in a car accident. They never would have imagined that this could have happened to them. So yeah, keep that in mind and understand that you have options. Thanks, everybody. We appreciate you listening, and we will catch you on the next one. Take care.
Bye.
You've been listening to Legacy Lawyers with Michael Haslam and Nathan Croxford. We give you the juicy detail of cases that our law firm has dealt with. We take out the lawyer talk and legalese and show you what options some of our clients had to choose from to fix their situation. The effects of not doing planning can be devastating. We'll be back soon, but in the meantime, hook up with us on Facebook and Instagram at Voyant Legal. Call us at 801-951-0500 or send us an email at team@voyantlegal.com. And for commonly asked questions, hit voyantlegal.com/resources. We'll see you next time.